All righty.
Hold on one second, Gordon. My internet is being slow. All right, we're live.
We're live. That's great. Give it one more minute. Does anybody notice anything different about me today?
Looks like you got a haircut.
And it looks like you're in the office.
Well, both of those are correct answers, but wasn't the answer I was looking for.
I don't know, Gordon, you look handsome every day, so you look more handsome today than normal?
That is an answer I'll accept any day of the week. Anyhow, I finally got beyond my miserly proclivities and forked out for a real camera on my laptop. So the problems I've been having with the technology will no longer recur. So if anybody puts something on the screen, it won't knock me off and that kind of thing. So I'll finally wait till we get to the last or next to the last meeting of the subcommittee to do it, but I'm here. So
Better late than never.
there you go. Well, why don't we start up, and if we have someone that joins us in process, they'll come along. Very good. Let me read from the obligatory. Members of the subcommittee are hereby advised of their duty under the State Ethics in Government Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this subcommittee with respect to which there is a conflict of interest or an appearance of conflict. Does anyone have a conflict that they need to disclose? If not, we'll proceed without that. There are draft minutes that are attached to your materials. Hopefully you've had an opportunity to look at them. Are there any suggestions for modification or correction? If not, I'll entertain a motion to approve.
I move to approve the minutes.
Is there a second?
Second.
It's been seconded. All in favor, say aye.
Aye.
I think we've got all the ayes. So that's unanimous, I believe. All right, so they are approved. Well, good. We are going to draft revisions of Rule 26, the appellate rule, and also the administrative rule. But before we do that, would like to get to the report that we got a taste of last time from Cameron when he reviewed what other jurisdictions were doing. In your materials, you've got quite a compilation on a district by district basis of what the districts are doing. And I think it's interesting to see that some do nothing, some do something, and something do a lot of something. So Cameron, if you're ready, willing, and able, let's go through and do a summary presentation of what you have. I would anticipate that this will become a sort of a chapter in our report for context, and also in support of a recommendation that the committee will probably make to our to the issues committee, that we set up or that we make a recommendation that we ask the AOC to invest some time and personnel into getting a central registry set up for secure leave. So anyhow, Cameron, go ahead.
Yeah, I mean, I realize now that the report scanned in kind of cockeyed, and I apologize for that. That's a user error. I think it largely speaks for itself. And if you go through, what you'll notice is, as Gordon noted, there are a lot of jurisdictions that don't do anything, and presumably leave practitioners to just adhere to the text of Rule 26 as written. There are a number that, sort of impose ministerial rules, like you need to file here, you need to file there. You might have a district that requires you to file if you're a domestic practitioner with the family court coordinator, or, in any number of other districts, the various trial court coordinators and trial court administrators. There were a few districts, and we touched on these last time, that have some kind of interesting substantive additions. And I'll touch on a few of my favorite. District 29B, which is Henderson, Polk, and Transylvania counties, they extend Rule 26 beyond licensed attorneys and allow pro se litigants to avail themselves of secure leave, which I think is kind of fascinating. Let's see, there was one more that I thought was really good that we discussed last time. And oh yeah, okay, District 20A, Montgomery and Stanley counties. In district court, in addition to designating secure leave, they have a standard local form that allows attorneys who practice in district court in those two counties to designate time off specifically for continuing legal education. So you don't have to cut into your vacation time in District 20A to get your CLE hours. Beyond those, if anybody has any questions, I'll be happy to entertain them. But as I said earlier, I think and I hope that the report speaks for itself.
Certainly some of the forms for designation of secure leave suggest that it can be time consuming and take a lot of personnel, particularly in more of the urban courthouses, to handle all of that.
Yes, you might have to submit designations to several different places depending on how diverse your practice is.
That's right. And I think that can be pointed to as some justification for trying to centralize the registration process. It won't completely do away, as Walter told us last time, with the need for personnel to route the information to the right place. But in terms of the total FTEs it would take to do it, it would bring it to a central spot and get it done from there. And I imagine there'd be a lot of savings to the state payroll anyway, if they don't run into any political issues from jurisdiction to jurisdiction. But that was eye-opening, as was a lot of the responses to the survey. So this is a lot of lessons learned with any of this. Mel, do you have anything new or additional to add to your thoughts on the process of centralizing the process of designation? And then I'll ask Walter the same thing, because you two have sort of been our advanced column on this.
The only thing I would say is that Brad Fowler indicated that he felt sure it could be done. And the way I have heard others talking, I think if we can allow them to work out what will work in the system, I think we can do it in one event, so to speak, and filing it and not having it to go through all the hoops that we've got right now.
Yeah. Good. Walter, anything to add from your post-vacation afterglow?
The reentry.
Yeah.
Yeah. Just a reminder to everybody that it's going to be a slow process as this e-courts rolls out across the state. So, and it's not going to happen overnight, and it's only going to happen in limited places for a while. And Mel, I got the impression that they were very anxious to actually enable this feature.
Yeah, I thought the same thing. I mean, I was so pleased that they weren't saying, wait a minute, we got too much on our plate already. Yeah. They did act like they wanted to do it and thought it would be a good thing for them.
Yeah. He did indicate to me, and I gather to you too, Mel, that they'd like some kind of official communication, whatever we decide that may be, to request that we have them enable that and staff it, because it is going to take some staffing, because it's not going to be automated, as I understand it. They're going to have to receive these designations and then manually enter the data, which is unfortunate. Maybe someday that'll be upgraded, but at least his description was now they basically will fill out similar form to what we're doing right now, electronically file that, and then they'll just have to manually process that, enter that data into their system.
Mel, in terms of the protocol for advancing that, I'd been thinking that when we turn in the report of the subcommittee, that we, hey, Drew, are you on? Yeah, hey.
I am. Hey, thanks everybody.
Very good.
Appreciate
Very good. Nice to have you with us.
Good to have you.
Drew, we're talking about the possible establishment of the central registry for receipt of secure leave requests. That we'll make recommendations to the issues committee, and that this would be one recommendation we make, and it would be up to the issues committee to decide what to do with it. Is that the appropriate protocol, Mel, in your view? Because
Sorry, I just had to take a call and cut it off. I missed
sorry.
exactly what you were asking. I apologize.
Yeah, I'm just not being, being a newbie when it comes to chairing a subcommittee. I'm thinking the appropriate protocol is to go back to our source of authority, which is the issues committee, and dump it in their lap, our report and recommendations. In particular, let Marcy Armstrong know that if a request is to go out to AOC, that it's got to come from either the issues committee with the blessing of the state bar executive committee, or whatever the hierarchy is. Mark, you've chaired committees before. What's your thought about the protocol?
I agree with you, Gordon. I think that's the right process. I think we can report back to the issues committee with really, I think, a recommendation. These are the changes we propose, and then anything we think in terms of the survey or promulgation or other stuff. And I think they take it from there. So I think that's how I guess I would understand.
Okay.
Would it be helpful if I approached Brad to find out exactly what he would need?
Yes.
I think so.
If you can, I think on that end, that would be very helpful. And then I think I'll approach Marcy on her end to see what she thinks she will do with it when she gets it. I think it's good that we know our audience and what we're writing for. But what I'm anticipating is that what you will receive before the October meeting is a work product that Cameron and Savannah and yours truly will be working on, that will be a compilation of some of the things we've done, and with the recommendations, including what we're just about to undertake now to try to finalize the wording of the rules and get that before them. Obviously, it'll be the focus will be the wording of rules 26, 31, 33.1, and the administrative rule. But there'll be some reasoning associated with it, some commentary, and then some of the empirical information that has been compiled that will go with it. But the recommendations coming from the committee is coming from a committee, and I want everyone to be comfortable with what we're saying. So that'll come around to you for review and comment. And I'd like to try to get that out to the issues committee a couple of weeks before the state bar meets in, I think it's the first full week of October. It's early this year. That's what the hustle is all about. So anyhow, so are there any other questions about what the steps, I'm anticipating the steps are going to be? Cameron won't get any sleep for a few days. Savannah will be back from vacation and totally refreshed and ready to go. Okay. All right. If you go to page 64 of the materials for this week, This is it's revision number 2 of Rule 26. We had a really lively discussion earlier this month at the last meeting. We reserved some of the more policy laden decisions on what calls to make on certain things here. You'll see those might be bracketed and left as alternatives. And what I'd like to do is follow the pattern jury version or methodology for going through this. And I'm going to pick on everyone, if I can, to go through this. What pattern jury does to get through these is I'll pick on someone to read a paragraph and everybody follows along. That way you see it, you hear it said, and then we'll comment on it. We'll see if there's anything we want to change or we pass it as a group. Why don't we start? And I'm going to go in the order of the way my screen is arranged from top left and across. So Cameron, you're at the plate. You'll start with 26A.
All right, 26A. Definition, entitlement. A secure leave period is a block of time designated by an attorney during which the superior courts and the district courts may not hold a proceeding in any case in which that attorney is an attorney of record. An attorney is entitled to enjoy a secure leave period that has been designated according to this rule. Did I get it right?
Hey, you got it right. All right, so you've heard the reading of the word. Now, any comment on that? Any thoughts for revision, modification, edit? I don't want to hear anything about Oxford Commerce. Okay. Does not appear to be controversial. Let's go on to B1. That would be me. B1. Secure leave.
Gordon,
Yeah.
what page is that on?
64 in
Okay.
you should have it should be paginated for you. Lower right hand side. Signal when you have it.
Taking a while.
Mel, you can just enter 64 in the middle bottom of that PDF and it'll go to the page for you.
Okay, I got it.
Okay.
I learned that from an associate. I feel real clever now.
All right. I'm on paragraph B, allowance, sub 1. Secure leave for any purpose. Within a calendar year, an attorney may enjoy up to 20 days of secure leave for any purpose. Secure leave designated under this subsection may be taken in minimum blocks of 2 consecutive days, provided the total number of days designated and taken do not exceed 20 days in a single calendar year. Saturdays, Sundays, and holidays observed by the courts of North Carolina shall be disregarded for counting purposes. A secure leave period that crosses from one calendar year into another counts against the attorney's allowance for the calendar year in which the day occurs. Thoughts, edits, revisions? Note.
I know there's a footnote there, Gordon. Do you want to read that now or just at the bottom?
Yes, let's read this. This will become, it's not part of what is being tendered as the rule, but it will become a comment later. I'll explain how this is counted. A designated day followed by a court holiday followed by a designated day shall be counted as 2 consecutive days. A designated Friday followed by a Saturday, Sunday, and a designated Monday shall be counted as 2 consecutive days. Okay. Is that to everybody's understanding? We agree this is what we're doing. Okay. B2. Mel Wright.
Secure leave for birth or adoption. Within the 24 weeks after the birth or adoption of an attorney's child, the attorney may enjoy 12 additional weeks of secured leave for the purpose of caring for the child. Secure leave periods designated under this subsection shall be taken in blocks of time consisting of complete calendar weeks.
Okay. I think one of the points of discussion last time was the allowance for birth or adoption is a little bit different than for secure leave for vacation. And that it doesn't lend itself readily to 2-day blocks. So at least for purposes of further discussion, it's been limited to complete calendar weeks. It's not written in stone, but it seemed to make sense to do that because you're talking not necessarily about going somewhere. You're talking about being at home, taking care of someone, being with a family, helping raise someone, or getting a child acclimated to a new residence. But there may be other opinions on that. So I open the floor for that discussion.
I just have a grammar issue. In B1, we say an attorney may enjoy up to 20 days. In 2, we say the attorney may enjoy 12 additional weeks. So I would either add enjoy up to or strike up to in B1 so that they read similar.
All right. We have someone who believes we should be consistent between 2 paragraphs in the same section. Anybody think that that's a good idea? I see head shaking. All right.
So,
The Catherine initiative is agreed to.
so hey, Gordon, one thing, and Catherine, one thought. So I agree. We should keep it consistent. And maybe I might be being dense, so don't shoot me just yet. I gotta sort of read this, but is the secure leave saying that is 12 additional weeks? Like is the idea is that it's sort of above and beyond, right, what is already existing in secure leave? So Catherine, you're saying we should say the attorney may enjoy up to 12 additional weeks. Is that the idea?
Yes,
Okay.
and that I read it the same way. I don't think it would be harmful to just say specifically that this can be used in addition to B1 and have that as a separate sentence, just for clarification purposes.
Okay, so Catherine, your proposal is in B2 to add that attorney may enjoy up to 12 additional weeks. Is that what we're saying?
I guess if it's my initiative and I get to, I would drop up to in B1, and then in 2, I would just say that attorney may enjoy 12 weeks of secure leave. And then at the end of that sentence, say the time exercised under this subsection is in addition to time exercised under B1.
Okay.
Or something less wordy.
I like that. Or just saying in B2, like in addition to the time set forth in B1, comma, and then just let it roll.
Yep.
Okay.
I mean, and that, that's clear in the current draft. But I like Catherine's idea of sort of like making it abundantly clear, and then you sort of see it up front. I had to kind of look at it for a minute to think about it, like whether I had additional time, right?
All right.
So if we're not going to talk about Oxford commas, we can talk about redundancy, can't we? Gordon, would you permit that?
Let me check. Yes, here in my manual, the Department of Redundancy Department.
So
we can discuss this.
Yeah, I like Drew's suggestion that we start with something to the effect of, in addition to the 20 days permitted by subsection 1, that we start with that, because that makes it abundantly clear. But then we would want to delete the additional weeks within the text of what we already have. Or unless we want to be redundant, and if we want to, then we can do it over and over again.
That makes sense, Walter. I agree.
I was expecting Gordon to call me on my redundancy in my suggestion, but he was concentrating on writing.
Yeah, we got to.
One random thought too is that so just on process, right? Like these would go to to once the bar makes the proposal, right? I would think that Grant Buckner would probably sort of want to look at this language and talk about it with with the members of the court, right? And Grant's a good rule draft, a really good rule drafter. He's got a lot of experience. He sort of has strong thoughts about like how to say things. So some of this stuff might get changed around anyway. I mean, I'm saying that as somebody who's prone to tinker with every last little thing. So y'all can definitely tell me to shut up, but I'm especially saying that because we might tinker with this, and then Grant might just rewrite it. I mean, the substance will stay the same, but he'll rewrite it.
Okay. I was thinking, what if it read something like this? The 24-week allowance in B2 is in addition to the 20-day secure leave allowance in B1. The 24-week secure leave allowance in B2 is in addition to the 20-day secure leave allowance in B1. That is redundant, but it makes it clear. I started out with the in addition to, but I got crossed up on how it would end. Drew, you got to finish for me. You got to.
Oh, I'm fine. I'd be fine with what you propose, Gordon. If we wanted to do it the in addition way, I think you could say something like, in addition to, so subsection B is entitled allowance, right? So you could just tie it back to that. In addition to the allowance set forth in 26B1, comma, and then let it roll from there. Lowercase w within.
Well, in addition to the allowance in B1, here's where you get then you don't want to say, all right, in addition to the allowance in B1, then where do you go? Because you don't want to say addition again.
Yeah, I'd probably say something like, I mean, there's a dozen ways to do this, right? All of them are excellent. But if we were to start with the in addition to, you could say, in addition to the allowance set forth in subsection B1, comma, within the 24 weeks after the birth or adoption of an attorney's child, comma, that attorney may enjoy 12 weeks. You could strike additional there of secured leave for the purpose of caring for the child. Although, that's such a wordy sentence with so many separate clauses. And then you get into in addition to the allowance set forth above, and then the very next part of that sentence is talking about the weeks after the birth or adoption of an attorney's child. It's almost sort of complicated. I might like your Vic better, Gordon, where you just have a separate sentence that just says, this time, the time in B2 is in addition to the allowance in B1. I don't know. I'm easy either way.
Okay. Well, probably the best economy would be the secure leave allowance in B2 is in addition to the secure leave allowance in B1. We don't have to repeat what those allowances are in terms of quantities of days. And allowance means, by definition, up to, because that's the allowance. If you want something a little more meaty than that, now's the time.
Sounds good to me, Gordon.
I don't think it needs to be any meatier.
Agreed.
Catherine, I don't think it would be wrong to add up to 12 additional weeks or up to 12 weeks. Strike additional there. Because we don't need additional anymore, but up to 12 weeks.
I actually wonder if we want I'm sorry to interrupt you, Gordon. I'm thinking about it, but I'm not sure we want up to, right? We define the amount of secured leave as 12 weeks. You can take as much as you want, but you get 12 weeks.
Okay. Would you want to take the word up out of B1 then?
Probably.
And that's fine. I think.
I mean, we can talk about it, but it seems to me I don't know. I guess the question is, do you have that much leave and then you file the designation, or does it come into existence when you file and therefore you could take that much? I guess you could think about it either way. I see Walter smiling, but I don't know. I guess that's the question is, do you have the leave and you're just designating it, or does it get created when you file the designation? In which case, maybe if it's the latter, then up to makes sense. If it's the former, it doesn't.
Art, did you major in philosophy?
I think we probably ought to be consistent, and I think taking up to out of B1 is probably just fine, because the word is may enjoy 20 days. I think, and Catherine was onto something to try to make it consistent. So I think, and if we call it an allowance later, that's I think that seals it. Is everybody happy with the you're going to see this again. Don't worry. Everybody okay with that? All right. Why don't we move on? The next one, let's see, coming down. Walter, why don't you do C and D?
I'll do that, but we didn't discuss the substance of that last sentence. Was there?
Oh, I'm sorry.
I didn't know if there were any
Yeah.
comments about that.
Let's go back to B2 in that last sentence, which is, you're right. Do we need to, is it necessary to state that or just not deal with it? Or should we provide some guidance, some minimum?
My first reaction is, why are we telling people they have to take a full week? You know, I just, we're just sort of making a judgment there of what makes sense for people when it may not for an individual.
One reason may be that in B1, we're dealing with weekends differently than we're dealing with them in B2, or at least the way this is set out. So we're not dealing, it's like apples and oranges.
I don't necessarily have an objection to it. I just
Yeah.
raise a question for discussion.
Yeah,
I see the difference. I see the reason that they're treated differently, and we certainly have to write the subsections differently since we aren't dealing with weekends and consecutive days and things like that.
So Walter, I see your point. I mean, I can think of situations where, if an adoption was scheduled for a Friday, or, if somebody was going to be induced on a Friday or whatever it was, that they may not want to sort of take like that, burn a whole week, right? For that. The flip side of that, I just remember when I think it was the Appellate Rules Committee, actually, when the Supreme Court asked the committee to sort of, for its input when it was considering the secure leave for birth or adoption rule. I was kind of surprised, actually, from some of the comments from some folks like me that do, frankly, more trial work than appellate work. And I didn't have this comment, but I remember one of them saying, man, that's that's a long time where you could shut down a case potentially with that many weeks. And if we broke it, if we allowed it to be taken in weeks, in phases where it wasn't a week long, if you sort of allow that amount of time the way you did and the way we do in B1, you might be able to shut down a case. Again, I sort of think that like secure leave abuse is not a thing. But maybe it would be if you had a situation like that. I don't know. Maybe one way to sort of, I'm making this up on the fly, but maybe one way to like bridge those two concerns might be to say something like, to at least have to take it in blocks of time for, say, 10 of the 12 weeks, and then maybe 2 of the other weeks could be split. Whereas I don't know, maybe that's just sort of inviting more confusion.
Remember that they partially address this later in the rules. If you skip over to subsection F2.
Yep.
That's on page 66. and you see there's a paragraph, child / adoption exceptions, and then the black print is in the original. And I think this has to do with, you don't know when your child's going to be born. It could be early. And if you put in for leave, might not be early enough, or it could be late. Put in too early, may not fit. Or if the child doesn't come, if it's a calendar week, they're not starting you on that's taken out of place. So you're not having to start on a Sunday with the birth every time. That's all the way that's been redone, but it gives the court the inherent authority to make it fair. So I don't know what the answer to that is.
That's a good point. That's a good point. I mean, there's flexibility there in the rule. And then, so maybe, we're going to go back to your point about, when you're taking secure leave for child related reasons, it's usually, big blocks of weeks, because you're not looking to, go somewhere. I'm probably fine with it as written.
Well, anybody got a comment? Shelley, Catherine, Mark? Anybody? Cameron? No?
I guess I would leave it the way it is, be my leaning, but I don't feel that strongly about it.
Okay. All right. Well, let's, at this point, why don't we go on to C and D? None of these, unless there's something else on B2. And then Walter, tee you up for these. They don't appear to be too controversial.
Subsection C, form of designation. An attorney must designate his or her secure leave periods in writing.
Okay.
Yeah.
Any comment?
Is there any reason we just can't delete his and her?
I don't see any reason why we should have to keep them.
Yeah, I agree. I can think of two ways to do it that I typically do. I mean, you could repeat attorney, or you could make it plural. I'll typically make it plural and just say there. And then talk about attorneys in the plural.
Yeah.
I think if you do that, make it plural, that eliminates the his and her. So that would read fine to me.
Yeah. So I might say, like, in the event attorneys S' plans for secure leave change in whole or in part for any reason, they may move their secure leave to a different period by serving written notice of. Or attorneys may move their secure leave.
All right. So on C, where we've got an attorney must designate his or her secure leave periods in writing. At my age, using a plural pronoun with a singular actor would get me flunked from Mrs. Murray's first grade class.
Yeah. Mel's
I could go
suggestion.
with attorneys must designate their secure leave periods in writing, or an attorney must designate secure leave periods in writing, and take out the pronouns, because I don't know that the possessive adds much there. I know there has got to be a substitute for gender designation. I don't know. I will keep my mouth shut on this and let younger people make this decision. But I can go with any of those solutions, including the there. But it's to me, it's hard for the grammar to do that. His or her is not good grammar either. I think, you know, it's appropriate because we acknowledge that attorneys are of both genders, but there's no reason to even have the pronoun there. Might be. Anyhow, who's our grammarian on this thing? Young grammarian, Cameron.
I'm for attorneys must designate secured leave periods in writing, but that's also because, as we learned on August 10th, Savannah and I favor using as the smallest number of words possible to get the point across.
The Hemingway rule. Okay.
In writing, at least. I talk way too much.
Okay. Hemingway rule. The suggestion would be attorneys must designate secure leave periods in writing. What do you think?
Yes.
Yep.
1, 2, 3, 4. Any?
So then a more substantive question is, do we want to say on a form approved by the AOC? Because we know that it will eventually be information that the AOC will be entering into its system.
Let's take a straw poll. How many of us designates it on an AOC approved form? Walter. I don't. I've got a homegrown form that I've been using.
Okay,
So
that's easy enough.
it's not part of the rule now.
Yeah.
And Walter, you're about to read the contents paragraph for us.
Okay.
All right.
Subsection D, content of designation. An attorney's designation of a secure leave period must contain the following information. Subsection 1, the attorney's name, address, email, telephone number, and state bar number. 2, the date on which the secure leave period is to begin and the date on which it is to end. 3, the allowance that the secure leave period will count against, with reference to either subsection B1 or B2 of this rule. The dates of any previously designated secure leave periods that count against that allowance. A statement that the secure leave period is not being designated for the purpose of interfering with the timely disposition of any proceeding. A statement that the attorney has taken adequate measures to protect the interest of the attorney's clients during the secure leave period, and the attorney's signature and the date on which the attorney submits the designation.
Okay. Any comments on content? Walter raises a good question. Suppose a district passes a local rule that provides a form. I mean, this is the general rules of practice form, but suppose a local district form is promulgated. Should we make reference to that possibility?
My inclination would be not to, only because I think there's sort of a movement toward getting sort of away from like the patchwork of local practice and sort of closer toward a more streamlined, unified system of rules of practice that are in the general rules of practice. I've heard Grant Buckner and sort of others on the court articulate that at times. So it kind of, in some ways, it sort of like invites mischief too. If they're gonna have their own form, are they gonna sort of think are they gonna have their own local rules and stuff about when and how it should be taken that may conflict with these rules? And and that sort of relatedly, I feel terrible that I may have missed the discussion on sort of the idea of like a centralized repository for designating, but I'm really interested in that because I think that would go a long way. So, and sort of even mentioning about local forms might be sort of contrary to that too. But despite all that, I don't feel strongly about it. I just raised it.
Okay. I think it's a good point. What do you?
I'm just going to say, it'd be my hope that we have one form. I don't see a need for local forms if we're going to the extent that we're going to be doing this and having the help of e-courts and AOC. I would think one form would be sufficient.
Okay. Catherine, you and Shelley agree? Just we're not making any reference to local variants. Variant's a bad word these days anyway. Okay.
There may be.
Agree. You could do a comment. I'm sorry to interrupt. I think if you want Gordon to comment, noting that some jurisdictions have local forms, same way we're explaining the counting might be good to remind people, but I totally agree. We should be discouraging that and trying to move to uniform systems. So I think putting it in the rules seems to imply that's a good idea, and we all think it's a bad idea.
Yeah, but you also may want to have some paragraph towards the end for an exception or for something additional that would apply, and it could be written out in that little paragraph, would seem to me.
Okay. Well, is that something we would put in a comment to the rule, or make an allowance here for after 7 fulfill any other requirement? That would run contrary to what Drew's talking about, not to have anybody go looking for other requirements. The not encourage approach. Which trumps what? Does the general rules of practice, do they trump the local district rules?
That is a good question. I can take a peek. It's probably in the preamble of the rules of general practice, right? I can do that while we're talking here. I don't see anything in like a preamble or scope or anything like that. That's a good point. I mean, as a practical matter, if a local jurisdiction does something and you're in front of the local judges, that's particularly if you're, sort of out far away from Raleigh or Charlotte, it's going to be sort of local practice driven, right?
Yeah. Well, Mel, your thought then is to do what? Should we make allowance in this text or just deal with it in our commentary?
I think, well, I can't think of an example right now that would be appropriate or that would fulfill what I'm thinking, but somewhere in there, if there's some special exception because of health reasons or maybe it could be noted so that the court would understand that there may be a possible problem of getting back from medical care or treatment and the plane's late, and so you take an extra day. I don't know. And I don't have a place of where at this point I would suggest we do it, but just kind of keep that in the back of our minds as we go through this. May want to do something with it, we may not.
Okay. All right. Any other comment on the content part then? All right. E, where to submit designation. Until there are changes to the system, I don't know that this would change, even though, as we know from Cameron's work, some jurisdictions have particular directions to where you send things. And for example, domestic court, I guess, might be considered part of civil actions. But in places like Wake County and I guess Mecklenburg, domestic court has its own, would have its own billing, so to speak. But I think to be consistent in the way we're treating the his or her pronouns, we need to go through E 1 through 4 and make the change for consistency's sake. So this would be coming across to Shelley. What do we come across? If you would read E 1, 2, 3, and 4, and let's find these pronouns. We'll see if we can make the same changes.
Certainly. Do you want me to start with the note?
No, that's okay. The note won't survive our change. Yeah.
Right. Where to submit designation. 1, in criminal actions, the attorney must submit his or her designation of a secured leave period to the office of the district attorney for each prosecutorial district in which the attorney's criminal actions are pending. 2, in civil actions, the attorney must submit his or her designation of a secured leave period to the office of the senior resident superior court judge for each superior court district and to the office of the chief district court judge for each district court district in which the attorney's civil actions are pending. 3, in special proceedings and estate proceedings, the attorney must submit his or her designation of a secured leave period to the office of the clerk of the superior court of the county in which the attorney's special proceedings or estate proceedings are pending. 4, in juvenile proceedings, the attorney must submit his or her designation of a secured leave period to the juvenile case calendaring clerk in the office of the clerk of the superior court of the county in which the attorney's juvenile proceedings are pending.
Okay. I'm seeing 4 his or her combinations. Can we do the same thing we did previously and Hemingway that so that, for example, in number 1, in criminal actions, attorneys must submit designations of secure leave periods to the office of the district attorney. Is that going to work?
Yes.
Okay, those changes will be made right on through. Now, in the last line of each one of those, where the word attorneys appears as a singular possessive, it's okay. Is it okay to delete the word attorneys at that point as being redundant? because we're going to use the definite article V. It relates back. Is that okay?
Right.
All right.
So you would leave out the two words, the attorneys.
No, I would leave in the and take out attorneys. In which just, it would say, for example, in which the criminal actions are pending. Well, yeah, I would leave that. Actually, you could take out the. I see what you're saying. Anybody want to hold on to the. Mark, what do you think?
I don't honestly feel strongly on it.
Okay. How many people say the? How many people say the? All right, let's take it out. I see what he's saying. Okay, everybody here gets the order of Ernest Hemingway. Okay, good. All right, Catherine. You've gone.
Don't get to Catherine yet. One other consistency issue.
Okay.
In subsection 3 and 4, it refers to the county. And I think it ought to say each county, because it's presuming that they only have one county in which an estate or juvenile proceeding is pending. So in this, yeah, so the third line down on subsection 3, clerk of Superior Court of each county. And the third line of 4, Superior Court of each county.
Okay. Do juvenile proceedings proceeding counties or districts? I don't know the answer to the question. Does anybody? Special proceedings in estates, that would be in the county, right? In each county.
Right.
I see that. On that last one, does anybody know? Why don't we just change that to each county as well?
And I would think if you're talking about something in which like the local Department of Social Services is a party, that it would be, I don't know.
County.
Okay. Now, ding, ding, today's main event, paragraph F. Catherine.
Do you want me to read all of it at once or stop at certain points, since this is heavily changed?
Okay, why don't you go to F 1 and 2 and then stop there.
Okay. When to submit.
Just 1 and 2 in the black.
When to submit, modify, or withdraw designation. An attorney must submit his or her designation of a secure leave period, 1, at least 30, 45 days before the secure leave period begins, and 2, before a proceeding in any of the attorney's cases is scheduled for a time that conflicts with the secure leave period.
Okay. I think this is a point where we may have some differences of opinion and was held open for discussion. This ties back to the survey, and it was the number one issue with the lawyers by an overwhelming margin. And what they had trouble with was the 90. So certainly anything less than 90 was going to be a move in the right direction. And so we've had discussions at 30, and we've had discussions at 45. So let's resurrect those discussions and see what we want to do with this. I know just from rereading some summaries of where people were trending the last time we talked about these. Mel, I think you were thought long and hard about these, and I think you were thinking what might be more palatable to the courts is 45.
Yes, that was my opinion.
And then Mark was going back and forth at times, and I think he was coming out more at the 30 by the end. So I don't know if we can get you all to start this conversation, and then we'll all join in. Mark, why don't you speak to what your thoughts are on the 30?
Sure. I mean, I think we recognize that there should be some ability to, modify things because plans do change. So I think the time period to me is a balance. We have the 90-day period to submit it. The issue is, what if you submit it and then, your plans have changed or there's some other issue you need to modify, some ability to recoup that leave, balanced against the concern that if it's truly last minute, you could manipulate the system to designate a bunch of leave and then cancel it at the last minute when nothing can be scheduled in its place, and then just do kind of a rolling submission. So I think that's where we're going back and forth, is I think a period that's less than 90 days, but long enough that you can't end up in some kind of rolling leave periods makes sense. My thought on 30 is, you can't, if it's 30 days in advance and you're only getting 20 days of leave, you're not going to be able to do any kind of rolling leave. But again, I'm not wedded to that number, but that's where I think I was thinking about it in terms of trying to reduce the possibility of some kind of manipulative cancel/reschedule.
Okay. Mel?
I just felt that so much of what we do revolves around, it seems, 30 days. And we had been at 90, that I thought 45 was a good compromise, a little longer than 30, but less than 90.
And
I'm okay with 95. Again, I'm sorry, 45. 95 would be, no, I'm okay with 45. I don't feel strongly about it. I'm just articulating some of my thinking, but I'm good with 45. And I think we had fewer people on, Gordon, so we were thinking we'd get other people to chime in if they had thoughts that may not have been able to join the last discussion.
Yeah. So, well, let's go around the horn and see where people are coming out on this. Catherine, you read it while you were reading it. What were you drawn to? What numbers?
I don't feel strongly. Doesn't matter.
Okay. Shelley?
I don't feel strongly, but I lean towards 45 days.
Drew?
Selfishly, I like 30, but I think that the TCAs and the judges would probably prefer 45. And there is in the days of now under what Rule 5B1, I think, that allows for email service to sort of start running the clock at the same time. Having a secure leave designation that's longer than 30 days. Again, I don't think that secure leave abuse is a thing, but for those that do think it's a thing, that might also help there, because then they would take away the ability of folks to sort of have something noticed up, 30 days out, or, a big response, 30 days out, and then sort of immediately go and secure leave, right? If it's a 45-day window, then, you're sort of, the person designating secure leave is out in front, right, of whatever might happen in those 30-day periods. Again, I think that's remote, but it's maybe another reason. But I don't know. Has anybody asked is it worth getting input from like a Kelly Myers, or, somebody who's sort of a well-respected TCA, about whether 30 or 45 would be workable? I suspect they'll say 45, but I'm curious.
Yeah. I don't think they have been asked, but not a bad idea to see how they might react. Walter, what are your thoughts?
Sorry, Gordon, I've had to step away. I got a brief I got to file. I'll be back with you in just a few minutes.
Okay, very good. We'll go on to.
Okay, sorry about that.
That's okay. The younger set, Cameron, looking out over your long and prosperous legal career, because I look in my rearview mirror and I see where mine went. So, what do you think?
Well, I mean, it seems to me that if we've had to spend this much time discussing what the parties tasked with administrating this rule might think and might prefer, that perhaps we ought to just go with 45. Although, I mean, I'm not going to get head up either way.
Yeah. Well, let's do this, and while we're waiting for Walter to come back to us, Catherine, let's plow on through, because this relates. We've got people's thoughts on 30 and 45, and I think this may seal it when we look at what is really, I think, a pretty helpful addition that has gone lacking before. If you don't mind picking up after the existing language of where you left off, and read the rest of that new red material.
In the event an attorney's plans for secure leave change in whole or in part for any reason, the attorney may move his or her secure leave to a different period by serving written notice of 1, a modified secure leave period at least 30, 45 days before the modified secure leave period begins, and before a proceeding in any of the attorney's cases is scheduled for a time that conflicts with the modified secure leave period.
Okay, and continue.
In the event an attorney's plans for secure leave change in whole or in part for any reason, the attorney shall serve written notice of cancellation or withdrawal, in which case the number of days originally designated but not taken will not be counted against the attorney's annual allowance. Any modification, cancellation, or withdrawal of a previous secure leave designation shall be deemed to warrant such action is not being taken for purposes of interfering with the timely disposition of any proceeding.
Okay. And then we've got the current language that goes back to a B2 situation. All right. You see what this is designed to do is designed to answer the question, what happens if my plans change in whole or in part? So I have to modify or I did modify, or I have to modify my secure leave, or I have to cancel it. And then it gives that guidance. And again, 30 and 45 pick up there. And you have to see it in that context as well. So does that change anyone's thinking, or does it reinforce people's thinking about what they think is appropriate?
I'm good with 45.
Okay. Yeah, I don't know that it would change anything. It's still trying to be consistent with the court system and what the courts would expect of us ongoing. I see a his or her in there that I have to change. Overall, overall, is this a good thing, or are there parts of it that should be rewritten or revised? We still have to get to the may and shall alternatives down there, but it's,
The last paragraph that I read, I
Yeah.
don't understand it. That's why I felt like I was missing a word or something was going on. It's either too wordy or unclear to me what's being asked for.
okay. Yes, that's fair criticism. If it doesn't come across, it's not written right. So, all right. Well, at this point, unless Walter comes back with a different, with a convincing argument to the contrary, is everybody comfortable with going to the 45 days? Okay. So 45 it is.
I have a suggestion on the Catherine language.
Sure.
I think instead of the language shall be deemed to warrant, we should just say shall state that such action is not being taken for purposes of interfering with the timely disposition of any proceeding. So we just we have you say that when you cancel.
Perfect. It's perfect.
I like it.
Perfect. Working on the Hemingway Award today, Mark. It's
Been
good.
my lifelong
It's
goal.
good. Yeah, it's
I'm
good.
already penciling it in on my resume pending the.
Okay. All right.
I'm going to try to make it a very concise notation.
Second line in the red, change his or her to the attorney may move the secure leave to a different period. Is that all right with everyone?
Yes.
And we're dealing with 45. Any other text changes before we get to the may versus shall? Okay, may versus shall. The penalty, I guess the implied penalty for not filing or accounting for changes on the fly would be that you lose it. Of course, in the form that you submit to get designation, when you designate, that's also provides for reconciliation, except you've got a gap in there where things may have changed that nobody knows about. So I guess do you put a forfeiture on somebody because they forgot to check back in and say, well, my plans changed and I didn't tell the AOC, or my plans so changed that I didn't take that week and I didn't tell the AOC and now I've lost it. Can't do it over.
I kind of think it's fair that if you designate it, you've designated it and you have that time off, and it doesn't, until you take some other action, you can't later say, well, I didn't actually go on vacation, I was in the office or whatever. I think that that's an appropriate consequence of designating it unless you submit it. I guess the only reason I'm wondering about May is if they just decide they're not worried about losing that week or the plans are still in flux, they can just, we make it optional. I don't know that people are harmed by their not updating it if they just want to leave it as a secured week, even if they end up not, even if they work out of the office.
From the standpoint of accountability, you would want to make it shall. From the standpoint of what's the goal of secure leave, it's mental health. Do you want to forfeit? Do you want to forfeit whatever got changed? And it could be, there could be extenuating circumstances. Death in the family, and you're not really thinking about your secure leave. That's a tough question. Shelley, you're sort of our designated mental health person on the subcommittee. What are your thoughts? Should
I think from a mental health standpoint, it should be May. However, I lean towards shall.
Okay. And your reasoning is?
Well, I mean, we're already increasing the amount of days available, and letting folks take them in smaller increments of time. I mean, I think we're adding in flexibility in a lot of places. I think and even here you have the opportunity to make other arrangements. It's just you've got to account for how you're doing that. I don't think it's a huge burden either.
Yeah. Okay. Very good. Anybody else? Walter, we're looking at while you were trying to not commit malpractice there, I think the group decided on 45 days. And we're dealing now with whether reporting modifications or cancellations should be mandatory or advisory. And it appears to me that we've got some advocates for mandatory at this point. And we have very faint praise for advisory. So it's trending. It's trending.
Yeah, I guess the point is, and I don't know how it reads in here right now. The point is, it would seem to me that the penalty is if you don't serve notice of cancellation, then you've used those days. Whether you intended to cancel them or not, you've used them. And so I'm not sure how to convey that notion clearest.
I agree with Walter. What if we just say that if an attorney serves written notice of cancellation, then the days designated will not be counted against the attorney's annual allowance?
I like that.
So we take out all in the event the plans change, you just say if an attorney serves written notice of cancellation or withdrawal, the days designated will not be counted against the allowance. So you file your designation.
And if you don't, they're going to be counting it against you, whether
Then
you
they
use them or
count.
not.
Correct.
Yeah, I'm okay with that.
Me too.
That's the Hemingway rule, Gordon. Less is more.
Have you heard of the Calvin Coolidge rule?
Well, my wife is a big fan of Calvin Coolidge, but I can't say that I have.
You've heard the old story about Calvin Coolidge. was at a political convention, and he was approached by two men who said, Mr. Coolidge, who were having an argument about whether who could get you to say 3 words. And I bet $100 I could get you to say 3 words. And he looked at him in the eye and said, "You lose." All right. All right. So what's your language? I like that too, by the way. Besides, when it comes from Mel Hemingway, you know, it's good stuff here. All right. Start that off again for me.
You want me to, I think what I said is, if the attorney serves written notice of cancellation or withdrawal, the days originally designated will not be counted against the attorney's annual allowance.
Likey.
I can see that award. It's gonna have the old man in the sea with the fish and stuff on the award.
I like that. I like that too. Wow. That's good. Yeah. Bravo. Bravo. Excellent. Excellent. Okay. Let's see. Drew? You just have to do depositions and other leave.
Yeah, and before
Unless you got
we,
something else on that.
well, so it sounds like I missed the battle royale about the Oxford comma, and I don't want to dredge that up again because that's not a hill that I want to die on. But I only ask as somebody who probably admittedly prefers an Oxford comma. Did y'all talk about consistency last time with the Oxford comma? And if you have, then I'll just stop. But it looks like there's an Oxford comma in other places in Rule 26, like in a D1 jumps out. There may be others, but
Let's see.
Well, Drew, I will just interject that I was very rudely and crudely advised that we would not negotiate over Oxford commas by the chair of this subcommittee, and I yield to the chair. My admiration for him is so great that I will not engage on Oxford commas.
Well, you know, unless you were born in Oxford, North Carolina, I would not know why the affinity for such things. But thanks for pointing that out. I have just exterminated that Oxford comma.
the one in up in D1.
Yep.
That's fine. That's just fine.
Yes. Thank you. Thank you. I was putting a bounty on them there for a while.
No problem. There may be more too, but Walter will surely find them. I'm confident.
Okay. Very good. All right. Why don't you read G and H for us, and I think we can close out Rule 26 here unless there's an overview.
Great.
Okay.
Yep. G, depositions. A party may not notice a deposition for a time that conflicts with a secure leave period that another party's attorney has designated according to this rule. Subsection H, other leave. Nothing in this rule limits the inherent power of the superior courts or the district courts to allow an attorney to enjoy leave that has not been designated according to this rule.
All right. Does anyone see anything in this these 2 paragraphs that are worthy of modification, change?
I wonder why we identify superior courts or district courts, but not the clerks, because part of this is before the clerk. So what about power of the small c courts to allow an attorney to enjoy leave that's not been designated? Wouldn't that encompass superior court, district court, and to the extent the clerk sits as a court.
It's a good point.
Yes, the rule is adopted for superior and district courts. I don't know if there's a definition of that going back to the beginning or not.
Well, we've got we got a special proceedings and estate proceedings subsection in which we refer to filing
That's right.
with the clerk.
Yep. I don't know the answer to that question, Walter.
Well, I guess we can change that and just say courts. And so it will apply to the Superior Court and the District Court. And if this rule applies to the clerk, it'll apply.
Yeah, I support that idea.
Okay. Got it. Yeah, I think that would, that's not going to do any harm to anything. There's certain references we'd have to keep, like Office of the Senior Resident Superior Court Judge. How would we deal with that? E2. We just leave those as they are, right? But otherwise, I think we can collapse it all into courts. I think that'll work very nicely. That'll be a nice move. Who came up with that idea? Whose idea was this?
Walters?
Who's not? Huh? It's a great idea. Good. Okay. That'll make it. The rule 33.1. My proposal on this is to take.
Nice, Mark.
Was it Mark?
Look at his background.
You rascal. Okay, very good. I'll get you for this. Anyhow, the rule 33.1, you'll see there's a lot of familiar language now that you've looked at rule 26. What I propose to do is to make parallel changes to that and then circulate it for you to look at. And then the administrative rules, sort of the same thing. It's a lot of the same stuff. So I think, given that we've been at this now for a little over an hour and a half, unless you want to, I don't know that we need to go through all this. What's the pleasure of the committee? Because I think we can adapt. It's really the same kind of changes.
Agreed.
Agreed.
Great. You're fighting me on this, Cameron. You really want to go through it all? Yeah.
Hey, man, I'm
Yeah.
I'm here at the pleasure of the
Okay,
subcommittee.
shake your head no if you really want to do it. Okay. Well, this has been great. Is there anything else that any of you want to bring up before we adjourn for the day? You all have been a very hard working group, and this has been a pleasure. I think we're just about there on the language. You'll be getting a revision very soon to look at, and what I'm planning to do. Maybe we'll have one more get together, but it'll be strictly for polishing, or if you read it in advance, we'll just sort of approve it and say it's okay. We'll look at maybe a good first draft of the report, and then that's it. It'll be fairly short meeting. You all have worked so hard that we can just go down the sliding board with the rest of it, and we'll probably do that maybe in a couple of weeks. That'll enable us to get the report out to the issues committee well in time for them to take a good hard look at it, and they can start hunting you down to talk to you about it and everything. But again, everybody's contribution is appreciated. And Mel, you think we're on the right track from standpoint of what you're seeing things that we don't see out there, and sensitivities and all that we're not visible to us, but I hope we're on the right track.
I think so, no question. I compliment the committee. Good job.
Okay.
So
Very good.
weren't we going to rely on Mel to get this before the Superior Court, District Court Judges Conference, maybe the clerks, before we submit this as a final? Is that feasible, Mel? Because we sure wouldn't want to submit this as a final proposal without getting that important feedback.
Let me call the judges conference tomorrow and find out. They probably have a meeting in October, but let me check and see.
Yeah. One of the things we got going for us is what we're going to be doing is to make a recommendation. We're making recommendations, and people can take the recommendations, know exactly what the group thinks, and they can start reacting to it. And if we're off, I think they'll be wanting to talk to folks, and certainly during a comment period or whatever they adopt, we'll have it. But that's the reason I asked the question of Mel. Mel operates in other universes than this little one, so it'll be good to have it. Anyhow, well, I wish everybody a good Labor Day. You've already paid it forward with your labor and everything. I hope that you have a Labor Day that's fun, that's full of good food and good beverage and very few words, except another please. Goodbye.
Thank you. Thank you.